Okay, everyone, I think we're ready to start. Welcome to our seminar today on the state of business and human rights today. And it's just a bit of background. Obviously, business and human rights, the whole field, is something that has really mushroomed and become a centre of a central focus over the last quarter of a century, in fact, and there have been a lot of developments in that area, and at the same time multinational human rights litigation has developed significantly, and that's globally, but in particular in the UK, which is an area that we have focused on since the early 1990s. And we've had cases which cover a whole range of areas: environmental cases, occupational disease, corporate complicity in human rights abuses, where state, public security or private security has perpetrated the abuse in which corporations have allegedly been complicit. So those are kind of the main areas. There are also cases involving corruption and more recently exploitation of child labour. Kind of sectors involved in the past has been mainly the extractive sector, mining and oil, but also chemical and agricultural sectors. But more recently, again, you will have seen that cases have become a bit more consumer focused. Kind of supply chain cases, I think, are on the horizon. In terms of countries involved, well, mainly African continent and some Latin America. And I think the nature of the cases and the geographical location of the cases reflects the fact that companies have operated with impunity in the past in the global south. And that's because regulations have been lax or not enforced at all, and because people who have been on the receiving end of corporate abuse have not been able to get access to justice. And that corporate impunity is what has led to the attempts that people have made, that we and others have been involved in, to hold corporations, multinationals, to account in their home states. And those cases have revolved around tort law, in England at least, and the notion that a parent company owes a legal duty of care to people who are on the receiving end of human rights abuse in the global south. So there have been a lot of developments on that front, which we will talk about in more detail in a while. Bringing cases in the home jurisdiction then gives rise to other difficulties, which again we will speak about around the areas of jurisdiction and the corporate veil, which have again been very central to the cases that have gone on here. Now, at the same time, as I said, that these cases have been developing, there has been this real explosion in the field of business and human rights. When we first started doing our cases, they weren't really regarded as human rights cases because only states were considered to have human rights obligations, not corporations. And that has changed a lot. And cases which didn't involve classical human rights abuses, like torture and slavery, again, were not really regarded as human rights cases. So cases involving infringements of economic and social rights weren't really seen as human rights cases in the past. All that has changed. And now the cases and the whole area of business and human rights, I would say, have kind of converged, and the cases have become integrated into the development of business and human rights. And you can see that most graphically if you think about the concept of human rights due diligence in the UN Guiding Principles on Business and Human Rights. That human rights due diligence is very much, or very similar to a tort-based duty of care. So you see it on that front, and then in the cases themselves, you're beginning to see reference to some of these human rights principles. So in some cases, reference to the voluntary principles on security and human rights. And no doubt in the future we will see references to companies having adopted the UNGPs, and that then forming the basis of a duty of care. So a lot of positive things there. I mean, these cases are not without the limitations, which we will also discuss, and there are also significant barriers to justice which still exist. And one area that I think we should mention specifically, which is not really so sexy in human rights conferences, is to do with financial viability of cases, which is so important as a matter of practicality. So we'll talk about that as well. So, look, I've said enough, and I will now introduce our 4 speakers. Where are they? Yeah, I'm delighted to welcome. So first of all, Dr. Katia Aristova, who is a postdoctoral fellow in human rights and practice at the Bonavero Institute of Human Rights. Katia serves as co-convener of Oxford Business and Human Rights Research Network, and in the past few years has served as a consultant on several research projects that have sought to strengthen corporate accountability for human rights violations, including for the UN. And she's also worked with us on quite a number of events in the last couple of years. Geert van Calster is a Belgian lawyer. Some of you have come across him before on a webinar in the last year. Is a Belgian lawyer, legal scholar focusing on conflict of laws, private international law, international trade law, EU and international environmental law, and EU economic law. And he's a professor of law at KU Leuven and was the head of its Department of European International Law for 11 years between 2009 and 2020. And he's a senior fellow at KU Leuven's Centre for Global Governance Studies. And he's also very knowledgeable about the Lugano Convention, which is something which is of particular interest to us. Richard Hermer, everyone in Leigh Day will know Richard Hermer. We've known him since he was a youth, really.
Certainly off the streets.
His practice spans public and private law litigation within both domestic and international spheres. And he's been instructed, mostly by us, I think, in some of the most high-profile cases heard by the English courts over the past decade, including nearly all of the parent company cases, including the Vedanta and Okpabi case, where Richard was the QC. Sapna Malik is one of our partners here, and she joined Leigh Day as a trainee 24 years ago. Blimey, that's
very young.
Oh, you haven't aged at all. And Sapna has run the most groundbreaking human rights cases in the wake of the wars in Iraq and Afghanistan, including the Belhaj rendition case, which resulted in the government apology in Parliament and the Iraqi civilian litigation, which was successful at trial. So that's a major case. Okay, well, let's start, shall we? Parent company liability. Richard, maybe you can just give us in a nutshell, where we've got to. in a couple of sentences.
Yeah, with pleasure. Before I do that, I'm going to start with the schmooze.
Yeah.
So, unsurprisingly, I often get asked to talk about business and human rights. Over the last 2 years, I've done it predominantly in shorts on a screen. And so it's a pleasure, to be doing an event with people sitting in a room together. But this is the natural and right place to be having it, because I've been a Zelig-like spectator for the last 15, 20 years, as you and Sapna and Martin and Dan and Ollie and others have developed this law. And it's really extraordinary. I mean, so we are, and I will answer your question in a second and tell you where we're at. But the only reason we're at it is because of the work of this department at Leigh, not only in terms of legal acumen and strategy, but also just sheer bravery in developing the law at the time when nobody else was even thinking about it. And for people who are here who aren't from Leigh, we should all be immensely grateful and impressed. For people who are here from Leigh, you should all be immensely proud of what people have done. So this is it's really extraordinary. So schmooze having done, but it's an important bit of schmoozing, and it's absolutely right to acknowledge that. The answer is, in terms of where we are with liability for multinational corporations, we are everywhere but yet nowhere. We're everywhere because these cases are now established, they are common, in the sense that no one says you can't hold a multinational corporation accountable in our courts for what it does overseas. That's now accepted. You can bring it for a range of type of cases. They're everything but yet nothing, because despite all the very interesting discourse about how we hold parent companies liable, the notions of it, the guidelines, etc., it's been established not on a special basis, but just on a normal tort basis for when any third party is liable. That's not an accident. That was a very deliberate strategy to bring the courts with us. So we are absolutely in a new world in which everything is possible in respect of parent company liability, but it's been done very deliberately within kind of wrapping ourselves in the cloak of English law tradition.
Good. And in terms of the principles, then, just briefly, what do we need to show? Well,
I mean, the basic underlying principle, whether we bring a case, and I know we're going to come on to discuss what laws apply, but whether you bring it in English law or in most laws of other foreign countries, is if you do wrong, the chances are you're going to have to provide a remedy to the person or the people that you have injured. And how you wrap that up, whether you're a parent company, can be done in a number of ways. But ultimately, what it boils down to is that you have acted in a way that makes it just and equitable to attach legal responsibility to your actions. So if you are a parent company and effectively you control what the subsidiary is doing on the ground, then you can be liable when that subsidiary fails to do things or does things that are legally objectionable. If you're a parent company and you said to the outside world, we're in control or we ensure that standards are going to be kept, then the courts will say, well, responsibility attaches to you. If you say, right, on this particular area, environment, protection of workers' rights, we're world leaders, parent company, then you'll be held to account. So it's really, and those are all principles that would apply to any third party in respect of liability. But that's the context in which it's been done for parent companies in the cases that you've all run.
And that's so important, isn't it? Because before we faced this conceptual obstacle of the corporate veil, which was always used as the reason for not achieving the kind of just result that you say is now possible.
Yeah, look, I mean, I think the motto that certainly I've always had, and shared by the people here I've been lucky enough to work with, is golden rule for strategic litigation is keep it simple. So you can have really kind of fascinating discussions about corporate veil and all sorts of clever ways of distinguishing a case from the corporate veil, or ways around it, or developing the law of corporate veil. But ultimately, we just decided to totally sidestep it and just say it's got nothing to do with the corporate veil. We're not holding you liable because you are the parent company. We're holding you liable because what you, parent company, have done. And it just rendered that whole debate sterile and irrelevant.
Now, we're talking about English law here, aren't we? So English law obviously applies when you're bringing a case in England involving a UK-based multinational. But that is important, isn't it? Because of the colonial history of Britain and the countries around the world that have an English law system.
Yeah. So just to kind of remind people, generally, the law that governs the dispute is the law in which the damage is sustained. So if the claimants are in country X, the law of country X will govern whether the parent company here are liable. Now, there's an interesting potential area of development, not least because of a Court of Appeal case from last week, which we maybe come on to later. But often in the cases, but not by no means always, the case arises in a country that has to which had a colonial relationship with the United Kingdom, Great Britain, and so they will have a common law tradition, and normally the same principles would apply. But actually, in the very many other cases in which it's civil law, not common law, more often than not, you'll find principles that mirror English law principles in respect of a liability of a parent company. Sometimes does it more helpfully, sometimes less helpfully, but the general underlying principles of all civil and common law liabilities, they share lots of features.
Yeah. Here in the European Union, they've had cases which have been brought along similar lines against Shell in the Netherlands and so on. What's your feeling about those? I gather there's been an important judgment in the Keerbell case in the Netherlands.
There was today, yes. I think generally, I'll get to Shell in a second. Generally, and here, by the way, for Leigh, I agree with Richard on that schmoozing. Generally, the principles, I think, are very, very similar. There's nothing really in civil law that would exclude, and of course, many of the EU member states would have a civil law background, not all of them, but many of them would. And there's nothing really that should exclude in principle a duty of care on the basis of, Napoleonic or whatever principles of liability. Sometimes, of course, that doesn't always work out. Today's judgment in the Netherlands against Shell, and as you know, Shell, of course, are being hauled before many courts in many places, although they've fled to the UK, as you probably also know, for tax and other reasons, and have left the Netherlands, or will soon. In Shell today, actually, the ruling was on the basis of Nigerian applicable law, which the Dutch courts, in a sort of shorthand way, just assumed to be very similar to English common law, and established on the facts today that Shell was not complicit on a particularly small charge of bribery, because all the rest had been thrown out on the basis of discovery and other elements. Now, there might be potential for appeal because the standard which the judges seem to have applied is more of a criminal law standard of beyond reasonable doubt rather than one of sort of balance of probabilities. And I suspect if there is going to be an appeal, it might be on the basis of those reasons. But I think the case also illustrates how very often in England, as indeed on the continent, the challenges tend to be of a different nature. There's CPR, civil procedure rules, which are very different. And we might get to some of those in terms of discovery, for instance. There is certainly the cost of litigation, which looks extremely different. In many European states, costs do not follow the event. And even if they do, there's a cap on the kind of costs. So in Belgium, for instance, that would be 30,000 euros for really complicated cases, as the Act would define it. And maximum 5,000 euros for more straightforward cases. which of course means that the sort of financial model looks very, very different, as indeed does the procedural model. But that doesn't mean to say, I think what is very encouraging is that because of strategic litigation in countries like the UK, Australia, the United States, the Netherlands, other jurisdictions are following. It's really taken the lead of a number of jurisdictions where these kinds of cases are brought for others to say, well, we should give it a go, despite all the procedural obstacles, cost obstacles, etc. And you can see that emerging quite intensively now. There's quite a lot of cases. I have one on the blog. That's my sales pitch here. But 2 seconds. I have a blog where I report on an insane amount of complex issues, if you're interested. I have one just now on an action in France against a French corporation for environmental damage in the Congo. And that's a case where these environmental NGOs, I'm sure, would not have dreamt of bringing these kinds of cases 2 or 3 years ago. And it's happening now. It's at the back of some European developments, of course, and we'll talk about that later, the human rights due diligence proposal. There is a European Parliament call for rules on third-party litigation funding, which I think is going to be very interesting, because before Parliament had this, hardly anyone in Europe had heard about third-party litigation other than civil procedure nerds. But so those kinds of developments, I think, are really, really crucial in driving this really twin approach between allowing perhaps to slightly more degree on statutory interventions like the human rights due diligence proposal in the EU and strategic litigation, which is something that we haven't traditionally done all that much, but is now happening.
Now, when you said that in civil law countries they will have legal principles which will enable liability to be imposed on a parent company in principle. But there are significant differences, aren't there, when it comes to disclosure of internal documents between common law jurisdictions.
Absolutely.
And civil
absolutely. So if you take, I practice as well as teach, and if you take a very practical example, we had a case against Ryanair where we took 3 years for a Belgian judge to oblige Ryanair to produce a number of internal documents on flights rota for staff. That was 3 years just to get that documentation. And that was quite, rare to actually ask the judge in an interim ruling, tell them to give us these documents. Ordinarily, you'd have to wait until you've submitted your own submissions and skeletons before you actually get to know what the other party have or might not have. And discovery is a very, very different process there as it is here. The upside of that, I suppose, is that we likewise do not suffer from some of the aggressive discovery tactics which you might have in things like SLAPs or Anthem Pillar orders, and particularly in Australian strategic interest litigation. This has been a real problem, where not so much or not just the lawyers, but the individuals behind the case are being harassed and served with these sort of orders where you'll have a team of private detectives turning up and searching your WhatsApp messages, etc., which is really intimidating, as you can imagine. So we do not suffer from those as much as indeed we neither have the benefits of some of the more proactive discovery mechanisms.
Let me just add 2 points on litigation in Europe. I think it's also important to note that most of the cases in Europe have proceeded as criminal claims. And in one of the recent studies that was released earlier this year, I've seen the statistics that in France, for example, from 2002, 12 out of 16 claims were of criminal nature. So that's quite characteristic as well. And then in terms of the second point I want to mention, to add, in terms of the viability of the claims and then availability of the legal basis, and I'll shamelessly share some of the results of the study that we have completed recently. So last month, the Bonnever Institute announced the publication of the book, which is called Civil Remedies and Human Rights in Flux, and this is part of the bigger project, and we specifically look at when and where civil claims can be brought against states and corporations for 3 types of abuses. That's assault and detention of persons, environmental harm, and unfair labor conditions. And happy to see Dr. Gruzic, who is a co-editor of the book with me. But what we did is we looked at 16 different jurisdictions, and out of those 16, the civil law are Argentina, Brazil, France, Germany, Netherlands, Philippines, Switzerland, and Ukraine. So it's quite a broad and quite interesting selection. And very briefly, the points that we saw some of the research findings. First of all, the narrative on separate legal personality is very strong, and peace in the corporate world narrative is still the dominant one in civil law jurisdictions. Second, there are statutes and there are general norms in the civil codes, as Geert said, that allow bringing claims alleging human rights violations. But general private law is not a persuasive regulatory tool, and our authors from these jurisdictions were quite cautious about the possibility of bringing novel causes of action similar to common law negligence, even though they are feasible. On the other hand, statutory schemes like strict liability, especially in the environmental realm, offer quite promising and interesting basis. And then the last point here is that we talk a lot about Western jurisdictions, but what we see in this study is that there are some interesting developments in Global South. For instance, we saw just one example in Brazil. There is a law that allows you in direct and indirect polluters. Now, there is some uncertainty about how remote you should be and the level of control, but at least it brings us to this realm of complicity and secondary liability. So there are very good reasons why these cases are brought in home states, but there are also some interesting developments happening in the Global South that are worth of looking as well.
And that's an important point, isn't it? That ideally it should be possible to bring these cases or bring these companies to book in the host states where the victims live, but not so easy in practice, unfortunately. Now we've gone on to talk about some of the access to justice hurdles, and Richard, you know about the problem that we now face post Brexit with forum non-conveniens. I mean, how do you see that playing out now? Is it going to be difficult to bring cases for people who live in most developing countries, or is that still going to be possible? How is this challenge now resurrected?
Okay, just to kind of give the framework and the background. So pre-Brexit, under the EU regime, Brussels recast, if you sued a multinational corporation who was domiciled in England or Wales, then the courts had to take jurisdiction, no matter what the events giving rise to the action were, or where they took place. If it took place in Zambia, it didn't matter if you sued the parent company who was domiciled in London. One of the myriad of things that Brexit has messed up is the certainty that gave. And so at the moment, and I know we're going to come and look at what the future might hold with Lugano Convention, but at the moment, all bets are off. And so it doesn't matter that the parent company is domiciled here. They are now able to come to the court and say, this case has got nothing to do with England. It's all to do with Zambia or the DRC, and the courts of those countries should be the ones where the claim is brought. Now that does change a very key dynamic that used to exist, where we knew that we could bring the case here, because there's no longer that certainty, and there is now always going to be a risk that the company is going to be able to persuade a court that actually the more appropriate forum is the foreign forum. And so that now brings into, although it was always in the background of one's mind, particularly if you were trying to bring in a foreign subsidiary at the same time pre-Brexit, but it now brings to the kind of forefront of your mind, anticipating at the beginning of a case forum arguments. So you have to ask yourself, can you realistically bring this case in that foreign country, or is the absence of an independent judiciary or funding for a case that is inevitably going to require funding of experts or access to lawyers? Is that going to prevent access to justice in real terms? And that is becoming much more of a feature at the front loading of a case, and much more significant question at the outset of the case than it used to be.
Yeah, and just to give an example of how oppressive that can be, and Sapna knows because she was involved. We're going to talk about the Cape case. Okay, go on. Well, I'll leave it to you. I mean.
Yeah, well, it was your case, but when I was a very junior solicitor working on it at the time, when we were facing those forum arguments, you saw the practical reality of that it actually meant years and years and years of litigation went by just arguing that alone, during which hundreds, maybe even thousands of our clients died. And these were clients with asbestosis, really severe asbestos disease, mesothelioma, and that with some of them their claims vanished with them. But they were in desperate need of recompense to have medical treatment. So these technical legal arguments, even when we eventually won in a great judgment, that was no good to the many hundreds who died. So even if we get there in the end, it does add uncertainty and delay.
Do you think that's consistent, Katia, with the principles of the UNGPs that these companies subscribe to, that they should be taking technical points like this, and that people will be denied access to justice in the process?
Of course not.
No, that's
of course
sorry, I wasn't accusing you. I wasn't
I'm not
saying
sure
you
whether
did
you
think
want
that.
me to elaborate on that, but no, and access to justice is often called the forgotten pillar of UNGPs. And there is a lot of discussion around state duties, around corporate responsibility now, the nature of due diligence, but there is still not much of a discussion between policymakers about structural barriers to justice. And even though probably the number of reports we've seen on the procedural hurdles is bigger than on any other pillar, but still there are hurdles that exist, and forum non-convenience, it's actually disappointing to see it back on the plate again, and back to those arguments forever and forever.
Well, law firms are also subject to the UN guiding principles. What about law firms acting for companies that take these points?
That's a good question. There is actually lots of debate around that as well.
I don't know if any of those people from those law firms are here.
Yeah, like you're asking about sort of applicable law to professional ethics.
If there are, maybe they could justify their actions. But
the forum non-point, I think, is really interesting. If you look at, this is like a little candy, which I think the English legal system is really rediscovering with great joy, right? There's 2 cases in the High Court last week, straightforward cases. Skiing in Courchevel, suing in England, 170 paragraphs on forum non, months and months of legal wrangling on a very straightforward case. Cypriot Trust, suing in England, again, similar idea. But even on the Brussels 1A, and this is a pivotal case, I think, and I'll get to Lugano at some point. I know Richard wants me to talk about Lugano. Even on the Brussels 1A, there is now a mechanism which allows for a sort of forum non-light, and the test case that is being brought is now in the UK courts. It's a case called Municipio. And in Municipio, we are suing an Australian and an English corporation. So there is an Australian pure forum non-element, and there's an English Article 34 Brussels 1A element. That's been going on for years. That'll be in the Court of Appeal again in May and June. And it'll be really interesting to see how the UK courts will be judging on a principle that, of course, they will no longer be applying, and then in turn how continental courts will be responding to the approach of the English courts. What's really interesting about Lugano, which the United Kingdom really wants to become a member of. So for those of you less in the know, Lugano Convention is the Lugano Convention is more or less a mirror image of the European regime on jurisdiction and enforcement in civil and commercial claims. And it is a convention between the EU and most of the member states of EFTA, the European Free Trade Association. Post-Brexit, the United Kingdom, to safeguard its legal services, wanted desperately to become part of Lugano, because if you're part of Lugano, the room for manoeuvre for a European continental judge to refuse your judgment, to refuse to recognise it, is very, very small. So the UK wanted to become part of this to safeguard legal services. The European Commission so far has said no, backed by the member states. There would have been a quicker route for the UK, which is to become a member of EFTA, but as you know, that's a red line, because if you're in EFTA, then you're subject to the jurisdiction of the European Court of Justice, which successive prime ministers in the United Kingdom have ruled out. European Union says no, mostly because it believes that it's too big a cherry to leave to the United Kingdom legal market. And, I suppose one can't really blame them. I also suspect that a number of statements by UK government ministers about the nature of the EU, etc., probably haven't helped in that analysis. But it is a sort of moving target, in that it's not the no, which is very clear at the moment, might indeed change in future. And the attractive element for business and human rights cases is that in Lugano, unlike in Brussels 1A, there is absolutely no possibility whatsoever of forum non. So not even this light version that we now have in Article 33, 34. So that would be a formidable,
So what do you say the percentage likelihood is at the moment of the UK being...
I think it's sort of, it kind of goes up and down a little bit.
Yeah.
Certainly the initial reaction of surely we're not going to give you this cherry has calmed down.
Yeah.
There have been better relationships between the UK and the European Union, and I suspect those will return. And as and when that will happen, I would imagine that there must be room for member states to give up that opposition.
Good. Can I ask you a question? We haven't had to face, in the business and human rights context, a full-blown forum argument post-Brexit. But would there be an argument available to an English judge that the common law rules on forum in respect of a case brought against a domiciled parent company, that the common law should develop consistently with Lugano Brussels recast, because for public policy reasons, because as a matter of public policy, one's going to want to have consistency, for the reasons we want to join Lugano. Is there scope there for a public policy argument to develop common law?
I would imagine there must be, although of course it might be difficult for a judge to sort of think in terms of strategic and policy considerations. What I would suggest must be, fairly straightforwardly established, is that if you're suing an English domiciled corporation for almost anything, then at the level of jurisdiction you should, as of right, be able to sue them in England.
Yeah.
Right? I can't see why that should not be fairly straightforwardly established, even post-Brexit.
Well, you can sue them. The question is whether they can decline jurisdiction.
Well, yes, of course. But I think, in the forum non-analysis, that to me must be the almost unmovable starting point for these kinds of cases. Particularly, indeed, if, as we have an increasing amount of due diligence requirements, which very often are also driven by banking and financial law, for instance, right? There's an awful lot of disclosure requirements on the basis of banking and finance. Very successful litigations in Australia have taken place on the civil shareholder suits, which move forward. And Client Earth, as you know, is trying that at the moment with a case against Shell's directors, purely on the basis of corporate law. And disclosure duty. So I think that's something which, to my mind, must play a very strong role, and it's certainly something which I hope in Municipio will be picked up by the Court of Appeal. But we'll have to wait and see, of course.
We're still on the topic of kind of barriers to justice, and forum non-conveniens. Lugano is one of them. Documents, access to documents is another. Sapna, maybe you could just, I referenced this at the beginning, this important issue that is often overlooked, I think, in academic circles about financial viability of cases. Maybe you could just explain some of the issues that...
and I think the system that we have here where generally costs follow the event, or for certain categories of cases where there is what's called one-way cost shifting, where claimants aren't liable for costs even if they lose a case, is one of the reasons why there have been so many cases here as opposed to the continent, for instance, because it means that for cases that we are bringing against major multinationals, against the Shells, the BPs, the whoever it may be, that we are able to really invest in the cases, because we know we won't, we're not going to necessarily win every one. That's what it is with the no win no fee regime. But if we do win, we can generally recover our costs that we have put in. And mention was made of third-party funding now increasingly in cases if the numbers stack up, if the cases are large enough number of claimants and damages, we might get third-party investors to help as well, which really means we're never going to be completely on a level playing field, I think, with the defendants. And we've just been having some fun and games in one of our cases where the defendants have been allowed to spend whatever they want fighting our case, and our costs have been significantly curtailed, but not to the extent that the defendants were actually pushing for, which would have been a sort of a tenth of what they can spend.
So just explain this proportionality principle that applies here.
Yeah, so I mean we do face a risk in cost recovery at the end of the day, that if the damages in a case are very low, that our costs might be curtailed a bit. But we recently had a very important judgment in one of the cases that I'm bringing with Richard, that Geert has blogged about as well, that proportionality in cases involving serious human rights allegations, in this case serious allegations of sexual assault and abuse on women tea plantation workers, the value of the claims, which just by virtue of where the women are, they're in Malawi, the damages levels would be very low, wouldn't be the only factor that a court would consider when it comes to assessing whether the costs in litigating those claims are proportionate. And the judge really focused on aspects such as vindication, the importance of vindication in the case, that the women, it wasn't just about money getting compensation, but also about trying to prevent the abuses and shining a spotlight on the abuses. So it was actually a very welcome judgment for particularly the smaller value cases that we bring, but that raise very, very serious issues of human rights. And in that case, we were facing an application from the defendant, a really bizarre application, I think we all felt, and particularly when they decided to sort of appeal their failure to get a cost cap that would cap our cost, the claimant's costs going forward, to a sum that they said they would have been entitled to had the claims fictitiously been brought in Malawi. And even though it was all accepted that the case could be brought in the UK, it is being brought against a UK multinational. So we were just facing this very sort of bizarre argument that the court rightly accepted Richard's arguments and our counsel's arguments that they were trying to bring Forum in via the back door, having withdrawn a strikeout application.
Yeah, that was an important decision, wasn't it? And I think these cost issues are so significant in our cases, the viability of the cases, and often overlooked. Let's talk about some of the limitations. I'm looking at Katia because she
that's
sent
my
me
job to criticize things.
She sent me a chapter and it had a whole section on the drawbacks of civil litigation, and I think some really important points to recognise and reflect on, I think.
Yeah, well, as a starting point, I think it's important to remember that litigation is only one element of the bigger solution, together with legislative developments that are adopted by individual states, but also multilateral accountability instrument. And it's quite often that I see the critique about using tort law to remedy human rights violations on the premise that private regulation and public regulation are not complementing each other, but should substitute each other. But that's not the case. So the assessment very much depends on the question you ask. If you ask, is tort law a perfect solution? The answer, no, it's not. But if you ask the question, is it nevertheless playing an important contributory role in strengthening corporate accountability, then of course there are many effects. Now, speaking about the limitations, well, because of the viability of the claims and all of the procedural hurdles, there is a danger of selectivity about how many cases can actually proceed and which cases. And this selectivity has many aspects. One is geographical, because we already mentioned that most of the cases are against parent companies incorporated in Western states. And this is, Europe, Canada, US, UK, to some extent Australia. There is a whole range of countries, China, that are out of the picture, for example. And again, I will point you out to the study that we are doing on the civil liability, and we are now working on the second stage of the project that might be of interest for all of you, because it will result in the publication of the online handbook for legal practitioners on civil liability later this year. And at the moment, we have country reports from 21 jurisdictions, including China, Cambodia, Colombia, Turkey, Bangladesh, Russia, Brazil. And again, the narrative on the very limited circumstances of parent company liability is a dominant one. It's not a global trend. The cases like Vedanta, Kpabi, Nefson in Canada are still an exception rather than a pattern.
You mentioned China, for instance. A lot of Chinese multinationals involved in the extractive sector in Latin America and on the African continent too. And this kind of litigation is not a possibility.
It's not happening at the moment. China is a very interesting jurisdiction generally because, along with Russia, for example, where I'm from, the issue of human rights is generally a quite sensitive issue. So, the reports that we have, they talk about legal system, the codes, but they avoid a lot of sensitive issues, partly because of the safety issues, etc. So sometimes the litigation is not possible for so many different reasons there. Then another issue with the selectivity is about generally translating human rights violations into tort law civil causes of action. And there is, again, most can be translated, but there are still some abuses that are not so straightforward. Access to education, discrimination, cultural rights of indigenous communities, environmental harm even. That said, still there are benefits of pursuing these claims, and they play a very important role, and there are many indirect benefits, including media attention, raising public awareness, capacity building, helping to see where are the regulatory gaps and where the reform is needed to be strengthened. And also there is a deterrence function of the cases like Vedanta and Kpabi, which of course impose a duty of care and will have an effect beyond individual cases. And if we talk about Vedanta and Kpabi, we have to mention that they open the possibility of bringing supply chain liability cases, because with the supply chains, the lead companies quite often have the practices where they make individual independent contractors sign up to settle internal codes or procurement practices and then implement them via training or social audits. And that is exactly what we see in Vedanta with implementing group-wide policies. So I don't, for example, see why we can't have an appropriate case where this argument is pursued in terms of supply liability. There is also the whole issue with the settlements, and because there is quite lots of criticism in academic circles about the compensation and settlement in the cases, whether you want to unpack that as well.
Yeah, we could answer all those questions. I mean, they're all valid. They're certainly all valid points. I think there are answers to all of them as well. If I just make one point about settlements. There are obviously reasons why settlements are confidential. If they weren't confidential, there might not be a settlement and people might not get redress, which is a primary objective of a case. And the second point to make about settlements, you mentioned the Vedanta case. Well, the Vedanta case was a case that was settled, and yet the Vedanta case has established a precedent which is going to have a wide-ranging benefit for not just for those victims, but for lots of other people as well. So the fact that the case was settled doesn't mean that it doesn't have a wider benefit.
Yeah.
So I don't know whether you want to pick up any of the other points about, I mean, for instance, characterising cases, human rights cases in the language of tort, I think is often a criticism that is, or concern that is expressed.
Yeah, I'm not worried about that. I mean, I think tort is just a tool. The objective is to provide redress and accountability for human rights violations, and you just pick whatever the appropriate tool is. That's why, some of the kind of big cases use tort law or civil law, others use public law, others use criminal law, depending on the jurisdiction, depending on the subject matter. And I think it's always a mistake for lawyers just to try and impose one kind of legal framework on a solution. It's how do you get accountability for what has gone wrong, and how do you get redress for those who've suffered? And we what's been done really effectively in this jurisdiction over 20 years here is to use tort law, and that's pretty crude, right? Tort law is pretty crude, and it absolutely doesn't apply to most instances of human rights violations. Absolutely doesn't apply to most instances of violations by multinational corporations, and that's what that. But it does play a really effective role for all the reasons that you've said. And even though, I'm a litigator, right? So I'm a cynic by nature, and I kind of think, well, all these guidelines are great, but it's basically a fig leaf for corporations, and you just got to sue them and make them feel the pain. But the reality is you can't for 99.8% of human rights violations in which they're involved. And so you have to have a framework. You have to have the guiding principles. You have to allow corporations to buy into it.
That man who just walked out got into trouble at one of the conferences where he said, "Sue the bastards." And some of the advocates of the UNGPs were not so happy about that.
I had this. You go to more than I do, because I just can't bear going to these kind of bean feasts in Geneva, which are talking shops, and all these corporations talking about everything they're doing on the guiding principles. And I do just think, well, just sue the bastards, because actually I know what it's like when you bring a case against them. But you have to, that is cathartic as that is. And as important as the tort law cases and suing people can be, for all the reasons you set out, actual in real terms to real victims, standard setting, deterrent, all those things that it can do, both in the case and its wider impact, it is really limited, because it's not a solution for all human rights violations everywhere.
No.
Can I ask a question, one small one for Richard? Do you think we can see an Efsun type of case in UK? Just for the audience, in Canada, Supreme Court said that it is at least arguable that a civil claim against multinational can be based on the violation of customary international law, and that will lead to the creation of new nominal tort. Do you think we can see something like that in the UK?
Yeah, but I do, but I don't think through the same route. So I think the answer here is, as ever, to just try and think it through established principles. And it's very hard to, I would have thought, let me put it the other way around. It's very difficult to see how something that could amount to a violation of a customary international norm could not be tortious, or you couldn't describe it or characterise it in a way that wasn't tortious. And that's the way I think, that's the simple way. Yeah, exactly.
Exactly. And so when you want to try and secure redress for the person you're representing, then you need to take the simple route. Sapna, one of the other concerns that's often levelled at civil litigation is that it only provides damages, and it's a very crude kind of remedy that's available. I mean, I think there have been cases recently where much more elaborate creative settlements have been reached.
So obviously the main tool or the main end goal of the litigation is monetary compensation. But if in several cases, not least Dan, leader over there, and us and many of us have, when we've managed to get into negotiations with the defendants and mediate cases, we've been able to come up with much more creative solutions that don't just apply to the claimants in that group, which are, as Katia was saying, can be quite a limited, selected group for various reasons, but wider community measures for quite often quite long lasting issues that have been actually, you know, whether it's to do with land access or gender training and scholarships, just that have been much more embedded and go beyond the case. So those have been, I think, for all of us involved in those settlements, and which has been spearheading as well, the sort of wider restorative justice measures are hugely satisfying, I think, both to us and to the clients as well. And it gives them a sense of empowerment that they're also, you know, helping a wider range of people
Rich, you're gonna say
in the
something,
community.
Well, obviously, I agree with Saps because I always do. But I was just thinking of an anecdote actually, which was, you know, people sort of say, you know, what was your best day ever as a lawyer? And I can tell you what my best day was, and it was all to do with restorative justice. So with Dan and I did the Mau Mau litigation, and we reached a settlement after 2 court victories. And as part of the settlement, we were thinking, and Dan, you know, Dan takes all the credit for it. We were thinking about this is a huge historical wrong. I mean, to which compensation was important to the victims, but, you know, it didn't begin to represent the magnitude of the allegations. And so part of it was an apology, which was exceptionally important, an acknowledgement of the wrong, exceptionally important. But the another aspect of it was the building of a memorial to the victims of colonial rule in Nairobi. And we didn't think it was necessarily going to happen. It was put up within a year. And Dan and I and the rest of the team were invited out. And literally I thought it was, for an unveiling, I thought it was going to be 12 people in a park in central Nairobi turning up, and we were walking down from our hotel, and suddenly we could see just thousands of people marching towards the centre of the park. And it was this day of it was the most extraordinary day I've ever had, perhaps the most joyous day as a lawyer I've ever had. But it struck me, it drove home to me in very real terms the importance of restorative justice. And so for all the you know, the valid criticisms of settlement, what settlement can enable you to do is to achieve justice in a much more holistic sense than most people appreciate. And I mean, that to me is just the kind of, you know, an example I will never forget of how restorative justice can work.
I've got another anecdote which follows that one, actually, which is I went to Nairobi on one of Dan's cases after a while later, and the taxi driver drove me through the main square, and he showed me the statue of Uhuru Kenyatta, and then he said, "Oh, and that's the Mau Mau statue there as well." I said, "Oh," I said, "Really?" He said it's much smaller because the lawyers took all the money. So sorry to spoil your story. But that's also a true story.
I was just gonna add one thing. Like when Rich was speaking, it was just occurring to me that in all the cases that we have done where there have been apologies, I think they've all just been cases against the state where they've been apologies. I'm not sure if we've ever done a case where the corporation has apologized. And you know, as you said, it's incredibly powerful. I've been in some of those rooms where it's been incredibly emotional when you've been sitting around the table and actually the perpetrator or the body representing the wrongdoer has actually had to fess up and say sorry to the survivors, to the individuals. And it's, again, it sort of goes beyond money. And if we get corporations to do that, I think it would go some.
Anita Ramasastri once said that business and human rights, this journey, it's not a sprint, it's a marathon. So maybe, you're still on the way to that, and there's creative settlements and all of the examples that you were telling is the milestones, but then we're getting somewhere.
There are lots of other points on my list, as you know, but let's since you mentioned business and human rights, let's perhaps just talk about then the wider context. Also, I think everyone will be interested in what's happening with the European directive.
Yeah, an awful lot, and it's easy to be cynical about it, I think, which I won't be. I think it's going to be really crucial to have, as I mentioned earlier, I believe in the twin approach of litigation, very, very firmly believe in litigation, speaking as a scholar as well as a practitioner, but I think that's a crucial point in trying to move this forward. I also think statute is very important. I think it's going to be needed to break cases like, we always think of events in Africa, etc. If you think of a case, Arica victims, I don't know if you know that case, dreadfully awful case of export of mining waste from Sweden to Chile, where this Swedish company, which is the bedrock of its local community, and which stands out as sort of like an example of Swedish efficiency, etc., is just refusing to budge on this issue of responsibility for something that is clearly their fault. And eventually won this case on the basis of, there's a documentary on it. So it's a bit of a spoiler alert, but I've been pessimistic about the outcome already anyway, so you probably know it doesn't end well, and they lose on a technicality of statutes of limitation and applicable law. When you see that movie, I think that's a very powerful push for something that is happening at the moment in the European Union. Now, the European Parliament, of course, so Arica Victims is the name of the documentary in the case, ARICA. Now, Parliament had wanted to have something really quite far-reaching, thankfully also at the back of many initiatives in the member states, right? And I will know more about this. There's been many member states, including France, of course, Switzerland, clearly another member state, but also places like Belgium, etc., where laws have been developing in the Netherlands sort of subsector, which has been great. When people ask me, should we still developing a law given that the EU is developing one, I said to them, well, absolutely. And the poorer the law, as in the more technically complex and ineffective and full of holes, the better, because that will give the European Commission an incentive to come up with their own proposal, which is exactly what they did. Now, there's been a lot of publicity around the fact that something, particularly EU quango, called the Regulatory Scrutiny Board, the RSB, which is a sort of institution within the EU that needs to check the regulatory validity and soundness of new initiatives. And they held up this proposal thrice, probably as a result of industry lobbying. And the European Parliament was very, very furious about this. And it's also quite likely that as a result of industry lobbying, the eventual Commission proposal has been watered down quite a bit. The catchment area is a lot less broad than it was supposed to be. SMEs largely fall outside of the scope, other than in a number of what are called problematic areas, or it's called something else, but sort of risk, I think is the word they use. Risk areas like mining, etc., where they would be covered if they exceed a certain threshold, etc. So the practicing lawyer in me, and I'm not even a corporate lawyer, of course, immediately thinks, if you want to escape the scope of application of this directive, you can probably do it, right? You set up some sort of a trading house rather than an actual big corporation and make sure that turnover stays outside of the EU and you'll be fine, more or less, right? So that's a cynical approach to this thing. But it will be very important to address one of the issues which Richard just mentioned, which is this element of qualification. And I absolutely agree that in these cases, the best thing is to do it really simple. Keep things simple, also because you don't want to confuse the judges, right? Because judges, of course, are not going to be an expert in all these fields. But at the same time, indeed, as Richard mentioned, there's only so much you can put into a tort qualification. And it probably doesn't always easily apply to hardcore human rights violations. It doesn't even apply to trade union rights and certain trade union rights, etc. And that's a problem. And if you have a statute like we will have, whatever it will look like eventually, in the EU that will oblige corporations to look at the value chain and the supply chain proactively, not just subcontractors and certainly not just daughter undertakings, but anyone involved in the supply chain, to look out for that proactively, to draft those reports. Again, I realize many of you will say, also report word and so on, but there will be a trail that will be reported for publicly listed corporations. There will be a clearly established duty of care. Whether it'll be easy to litigate, probably not. And one of the challenges there is that in the EU, we haven't had much success in harmonizing private law. Right? There's very little harmonization of private law. The Environmental Liability Directive, for instance, despite its grand name, hardly harmonizes tort. It looks at environmental liability in the first instance as a public law issue, and then sort of moves it on at the member state level to a private law issue. So that is clearly going to be a challenge, and this directive is not going to manage to harmonize issues of tort where previous initiatives have failed. But the fact that there will be a duty, that there will be reporting, that it will be clearly established that a corporation cannot simply say, I wasn't to know, I didn't look into it because it's the other side of the world, etc., I think will be addressed. Clearly there will be a problem of leakage to the degree that supply chain will continue to be global. And of course, if you think about sustainable consumption and production, that's a big if, I think, right? There's an awful lot of movement to bring back a lot of our source activities, but to the degree that it retains local, which it certainly will be in some of the risk areas like commodities, then of course the Chinese element is really quite problematic. And that's what people in the corporate field will tell you as well, that even those corporations which have a reach out program, which they continue over years and years to try and link farmers, for instance, to a sustainable long-term investment program, find it very difficult to compete against Chinese corporations. And that's something which quite clearly this proposal might not easily address. But even then, right, Chinese corporations have footholds in the EU. And at the jurisdictional level, as we've discussed, it's fairly straightforward to sue them. So beyond the jurisdictional level, of course, is the issue of merits, but at least you'll have a day in court. And the directive will help you establish some of that trail.
Katy, you optimistic?
I'm happy to be a cynical person, since that's my role today, to focus on negatives. I can do that. Well, I agree that it's good to have the proposal. We do have finally one, and it's an important step. As Geert said, the personal scope is quite narrow, so the directive will apply to very large companies and to large companies.
How does it compare with the French vigilance law?
The threshold is higher, so it's less companies that will be covered, I think. So what the number I've seen is that 1% of the companies in the EU, so relatively, that's not much. The high sectors are agriculture, textile, and extraction of minerals. Now, the problem is that there is no phased-in ambition to, for example, apply later on to small and medium enterprises, which could be a solution, like test how the directive applies on the large companies and then approach it to extend it to SMEs. There is no this ambition at the moment. There is also no explicit mention of the state-owned enterprises, which is a bit of a disappointment because state enterprises can set an example. The good thing is that there is a climate change provision and the companies are required to implement an act in accordant transition document in accordance with the Paris Agreement.
State-owned enterprises,
Yeah,
because
there
this
is
is
no
precisely
explicit
what
one.
the European countries were complaining about when there were discussions on the binding treaty.
Right.
the countries that advocated that had not included state-owned companies.
No, it's not included at the moment. But there is this climate change provision, although it's not enforceable. There is mention of the directors' duties. So the directors are now meant to take into account how their decisions impact human rights, sustainability, and environmental aspects. But enforcement is left to national laws. So the breach of duty will be in accordance with the national laws. There is very little space for stakeholder engagement, and I think that's the biggest disappointment for the civil society, because one of the articles says that the company, where relevant, can approach stakeholders for consultations, but making it optional is of course not a solution for many. And there is also a very limited and worded provision on the complaints procedure. So at the moment, the article says that the company has to set up a procedure allowing complaints to be filed or to be sent, and then for a possibility to follow up. So effectively, it means that setting a company hotline where you can give a call and say, complaining, or having an email will suffice. Of course, the devil is in the details, how it will be enforced. There are two elements of enforcement. There is public and private enforcement. So public, there will be a supervisory authority in each member state, and there are a few articles that in detail talk about the authority of these organs, what they will be able to do. So that's certainly a good thing, because, for example, we see with the French duty of vigilance law that lack of the enforcement authority is seen as one of the disadvantages, because there is too much pressure on the civil society to keep a track of the companies that have to implement the plan, have to issue the plan. So hopefully at least some of this pressure will be now on the public bodies. And then there is civil liability provision, which is framed as a failure to prevent, but there is a defense, and it applies to, before getting to defense, important to say that the directive covers due diligence obligations, cover company, its subsidiaries, and supply chains. And supply chains, both direct and indirect. But then it introduces this concept of established business relationship, which is a departure from the UN guiding principles. An established business relationship is a definition through the criteria of a lasting relationship, the length of the relationship. So the scary bit slightly, the concern is to what extent the companies will be able to avoid that by introducing more short-term contracts. And that's already some NGOs have been reporting, at least in some areas, in some industries, like fashion one, where the companies do jurisdictional forum shopping for cheap prices and enter into short contracts to ensure the cheap price, whether that will be an established business relationship. And then defense from civil liability works that it could be a defense if some procedures like contractual assurances and social audits were implemented in relation to indirect established business relationships, unless it was reasonable for the company to think that the harm would not be prevented. So it's so many different aspects, like this contractual assurance, how cascading it will be, like social audits and company trying to evade liability by hiring different certification schemes, etc. And then this introducing this reasonableness criteria when it is reasonable for the company to think that the harm would be prevented. So I assume that lots of litigation will see quite interesting on this reasonableness criteria and on the defense of liability. But it's good to have the proposal.
I think we've got about maybe just a few minutes left. And you were talking about supply chains and these business relationships. Sapna, Richard, I don't know whether you were talking about the kind of cases that might materialise in the future. And I think there's been a bit of a movement away from the traditional extractive sector cases. It does seem to be a bit different when you're dealing with consumer-facing companies, and maybe talk about the potential for supply chain cases as well.
Yep. Well, talking on the consumer case, I'm looking over to Dan there. Again, that we've seen quite a shift, or at least from some of the defendants, producing products that are very consumer friendly or facing in the UK, whether that's avocados or tea in some cases, rubies, diamonds as well, where they are keen to settle early or keen to settle certainly quite a few people probably saw the series of Sunday Times articles that were written last year, weren't they, exposing abuses at a Kenyan farm and around the farm, producing avocados sold in various supermarkets, and the sort of the shock and horror that people were, this sort of their avocado on their sourdough breakfast or whatever was kind of, tainted by these abuses, kind of turned the company around overnight, and from being a very aggressive and slightly going off the rails in some ways in terms of the litigation to coming to the table very quickly, and then engaging in negotiations, which resulted in one of those very wide-ranging settlements. And a similar case that we were bringing against a company in respect of tea, having quite a similar outcome. Doesn't happen with all of them. We're about less than 3 months away from trial against another tea producing company, parent company. So sometimes I think it does again depend on the individuals involved, and whether it's a public company with loads of shareholders potentially to a much smaller private limited company where the individuals involved may play a much bigger role in the way the litigation runs. And in terms of other sorts of cases, I think quite a lot of people would have seen the recent coverage on the Dyson case that Ollie is bringing. A very long
TV
piece.
star there.
TV star.
Had his letter from Shillings, didn't you?
Yeah, you got the defamation stuff lined up, which again is another avenue that we're exploring with the right case, and trying to develop the law carefully in that area, moving forward from Vedanta.
Rich, what do you think about supply chain cases?
Yeah, look, there's no conceptual difficulty with supply chain, and you didn't need Vedanta to tell you that, actually. It all fits comfortably within both a negligence paradigm and, in the right case, also other legal wrongs. So another one of Ollie's cases is against British American Tobacco in Malawi, which is a much more kind of a classic supply chain. It's about child labour. The children, neither the children nor their parents work for BAT. They're about 2 removed up the chain, and conceptually, one can apply a pretty straightforward negligence analysis to that, but also unjust enrichment, which is the other legal basis on which the claim is brought. So I don't think there is, and in fact, actually, Geert, the case that Geert was involved in, to do with, very different facts and not really supply chain, but precisely the same model applied in respect to the Bangladesh shipbreaking case. So it's the idea that you don't have to have a direct relationship with the victim nor the subsidiary. It doesn't have to be a subsidiary. I don't see the law working in that way. I do think you can't just take any old case of supply chain and throw it out and say, well, unjust enrichment, negligence. It's that what's being applied is a slow, cautious, incremental approach, which is often the best way to develop the law. But there's absolutely no conceptual difficulty with it as a matter of English law.
Okay, well, that's a good note to end on, I think. Now, there's a lot of information that's been discussed. Has anyone got any questions or comments they want to raise? Sure.
Yeah, thanks very much for that. Yeah, I saw advertised that you're doing a case in South Africa about Uber drivers, and I wondered how, a claim about worker status, elsewhere in the world sort of relates with the tort claims that you've been talking about.
Yeah, well, that won't be a tort claim. It will be a claim under South African employment legislation, which is very similar to UK legislation. So the principles, I think, will be the same, and that case is going to be in the form of an opt-out class action, which is another important point to mention, that in England we don't have opt-out class actions, we have group actions, which are significantly different from opt-out class actions. It means that in England we have to take instructions from all the claimants who have to opt into a case, whereas in South Africa, where they have opt-out class actions, you can bring a case through just a few representatives. So yeah, that's be a very similar case, and of course that case has been litigated around the world for Uber drivers, largely successfully for the drivers. Yeah. Any other points? Sure.
I was just wondering, you mentioned earlier some difficulties with litigating in the home states. I'm wondering whether you've had experiences,
in the host states, in the
host states, exactly. And I'm wondering whether you can shed some more light on that in terms of whether you're talking about the judicial system or the experience of the lawyers there, etc. The other thing is that, connected with that, I'm wondering whether, in some of the cases you mentioned where for non-convenience is an issue, whether the courts look at all at the concept of exhaustion of local remedies, for example, or not.
Do you want to talk about forum non-convenience?
Yeah, sure. So, conceptually for me, if the real complaint is against the local company and not against the parent company, and if there is a realistic chance of access to justice for the victims in those countries, that's the place that the case is properly to be brought, to my mind. And I'm often with this kind of debate reminded, because one of my other kind of areas is kind of international public law and crossover to international humanitarian law, with the debate around the creation of the International Criminal Court and the Rome Statute, in which, again, this kind of principle was batted out, that if you can do something properly in state, better to do it there. But the reality, there's a difference when actually the real people who should be held responsible are the parent company domiciled here, because then I do think this is the place to which they should be held to account. But also, the reality is that in the places in which multinational corporations think they can get away with low environmental standards or low standards of health and safety for their workers, or complicity with local security forces in the mistreatment of people, those tend to be, not always, but they, the fair money is those are states in which there is not going to be an effective means of accountability before the local courts, either because those courts are corrupt, as in the case of some cases, or more often is the case, is that the country is not geared up for kind of, take an example, complicated environmental claims. So Vedanta, one aspect of Vedanta was kind of the parent company be liable, but another important aspect was looking at the question of access to justice in Zambia. And there, the court accepted the evidence that the claimants put in, that an environmental case of this magnitude required funding at a level that these claimants were never going to get under the Zambian legal system. That wasn't a criticism of Zambia, it was just the reality of the position in Zambia. And that was really real. I mean, people would never have got justice. Things can change, and in fact, I think the Cape case is an example of that. So Cape went to the House of Lords sort of 20 years ago on a forum convenience point, and the House of Lords, as it was then that the apex court said, it's unlike there's a substantial risk of injustice because you can't. It was post-apartheid, but the courts there at that stage were not geared up for big group litigation. But things have changed. You wouldn't run that argument now, I think, in respect to South Africa. You're running cases in South Africa. So things change, and but yeah, I
think if you and Sapna described some of the financial viability issues with cases. If you're in a host state where there is no funding and you're dependent on lawyers to run your case on some kind of contingency, assuming that's permissible, because in some countries it isn't permissible, but even if it is, you've got a very powerful company on the other side, a complex case which requires expert input, technical input. It's very expensive to run, and it's very difficult for lawyers anywhere actually, even in home states. It's largely too difficult, but in host states, the idea for a lawyer of contemplating taking on a big multinational corporation for a case which is going to be of unknown duration, huge cost, and unknown outcome. Imagine the cash flow consequences that would have. That explains, I think, a lot of the reason why it's so difficult, in addition to which there are all the other points that Richard mentioned.
Just that 2 points, Richard, just very briefly. One of them is, I think, it's one of the traps I find in Vedanta, so this Supreme Court judgment wherein Lord Briggs' speech, he says if it weren't for the point of third-party litigation funding and litigation funding generally, in the light of the potential submission of the defendants in Zambia, for some of the defendants, we would have sent it back there, right? That, I think, is really a rather unattractive part of that judgment that's had an impact on some other first instance judgments which have applied for an inconvenience for that reason. The defendants will submit to the jurisdiction of Mauritania, and therefore they should be there. I find that really problematic. But a second point is applicable law, which we haven't talked much about, and we should probably do summer school on these premises on all these issues. But applicable law is interesting because, of course, in practice you reverse engineer, right? And that's, of course, the same with jurisdiction. You don't sit down studying the academic works thinking where should we end up on the basis of X, Y, and Z. You say that's where we want to end up and we want that law. And what's interesting there is that particularly in environmental law and to some degree in occupational health and safety, the laws outside of the EU are often fantastic on paper. Right. So in Municipio, for instance, we are not at all saying that we want English law to apply because Brazilian environmental law is much more gorgeous than English environmental law, right? So, but we want it applied by an English judge. And I think that's really quite interesting when you think about the applicable law exercise. And that might very well be the same in some of these reporting duties, right? I mean, corporate finance might be fantastic in Mauritania. Why not have it applied by a judge in Sweden, say?
That's actually my experience as well with looking through many Global South jurisdictions, and that the written laws are actually quite good. And last year, for example, I've been reading the report from Philippines, and it lays down all of these possible legal bases that you can base your claim on. But there is no discussion of case law at all. And the question is like, why there are no cases then? And like, well, you can't bring the case because of the delays in justice. Like one case will go for 10 years. Like why would we bring the case? And these are all of the, and we're not talking also about, corruption, it depends of jurisdiction. That's all some characteristical problems in some jurisdictions as well.
Yeah, I was just going to add, just on your question about having to show exhaustion of domestic remedies, we don't have to show that, but certainly some cases have come to us where lawyers have tried to bring cases locally. The BP Columbia case, for instance, the first case we brought on that came to us because the lawyer herself had received so many death threats. I think her family members had been killed by paramilitaries. She'd sought asylum in the UK and came to us with the case. So there are those very graphic examples, I think, some of the other cases we've been involved in, again, they have tried to bring to seek local remedies, and that hasn't worked. So that's why they've come to us.
Maybe last question. Okay. This lady here behind Steve Bilko. Yeah, on the right. Yeah, you. Yeah.
So I think the main consensus I heard out of this was something along the lines of, I guess, like simple is best in terms of like strategic litigation.
Yeah.
From a legal point of view, and we also had a lot about, I guess, like different jurisdictions and their approach to these things, like the climate of litigation in those countries and their respective laws. I guess, so last week in Australia, there was a pretty prolific overturn of an appeal of a previous decision where a bunch of teenagers essentially sued the Minister for Environment, just on a very, very basic principle of it goes against their duty of care, the minister's duty of care to protect young people from the climate crisis because of the approval of an expansion of a coal mine. So I guess it seems that there there is a future for cases that are just extremely simple in nature, just going back to first principles of like, you know, duty of care, and a bunch of teenagers who brought this case and unfortunately have not been successful at this stage, but I know there have been other similar cases in Europe. So I guess from the perspective of, against like governments and the responsibility of governments for such offences, what do you think, I guess, the future in Europe and the UK looks like for, like, just, I guess, very basic, like using just duty of care to litigate on such big things as like, you don't deserve to die because of climate change?
We were just talking about climate change, weren't we, before,
exactly.
and we never got onto that subject. It's such a, you know,
I think my two sort of sense worth on this is you can see it in a place like Australia. It's very much wrapped in judicial review, government by judges sort of narrative, right? Because and I think in the Sharma case, that's what at least one of the justices mentioned this. We shouldn't be doing this, right? It's politics. That was to some degree also the case in the Netherlands in the first instance case, in Uganda, where the judges seemed to hesitate somewhat, but said at the end of the day, no, you know, this is a straightforward duty of care issue, and we should be holding on this. But I do think then we shouldn't underestimate the political pressure, particularly in climate change cases, of politics saying keep your hands off this. And it takes a confident judge, of thankfully there are plenty, to say, well, you know, you've had your hands on this in the case of climate change for 30 plus years, and you haven't been doing all that much. But in fact, you have agreed to quite a few things, including going back to 1992. So we'll just hold you to that, which is all that the Dutch courts did, and it's all that the Belgian courts did. The next step, of course, is your enforcement question, which will be also, on a technical issue, an interesting question for Shell, now that it's moved to the UK. What if there's going to be a further appeals judgment against Shell on climate change and its personal private responsibility, and it needs to be enforced against Shell in the United Kingdom, right? That would be interesting from an enforcement point of view, assuming that Shell would not abide by the judgment, that is, of course.
Do you want to say something, Richard?
Yeah, law is going to fail if it can't address climate change. Right, that's going to be an absolute total failure of using law to achieve accountability. That doesn't mean law can't fail. Outside the US, I'm not sure there's ever been successful litigation against cigarette manufacturers who create cigarettes that, when used as intended, kill millions of people. Right? So it doesn't mean that law is always going to succeed, but law has to succeed with climate change. And climate change is going to be what human rights will be about in the coming years. And that won't just be because of climate change, it will be because of the impacts of climate change that are going to have human rights ramifications that we can understand at the moment, and those that we don't yet understand what they're going to be, but they will be profound. What I would say in respect of how law should shape up and how strategies should be developed is that, you know, that one golden rule of litigation is keep it simple. The other golden rule of is be strategic. So the day one case shouldn't be the boldest, but there should be thought. And you know, there is stuff going on in this jurisdiction. You know, Client Earth has had some incredibly successful litigation in respect of not keeping the government to account on its legal obligations. It's undoubtedly the case that there's going to have to be more. It's undoubtedly the case that one's going to have to kind of push judges to realise the significance of the climate crisis, but it will happen.
And I mean, just to add to that, the importance of keeping things simple. I think, especially from the perspective of a practitioner, that is really important, because keeping things simple doesn't mean not being ambitious or not doing things that are novel or groundbreaking. It's just that these cases are just so complicated in so many ways that you don't want to add layers of complication that are unnecessary. And that's for the benefit of the clients, but also as a general strategy, it doesn't make sense. So. And I think that's where the development of tort law has come from, really.
the fact that you're using tort law doesn't mean that the facts of the case of the torture or whatever it was don't come out. They do. It's just that they're not characterised in that language. Okay, look, I think that's it, and we could have carried on for ages, and we've just touched the surface of lots of these things. I don't know how intelligible it's been, and I've kind of jumped from one point to another, so it's my fault if it's lacked coherence completely. But look, I just want to thank our 4 speakers for all their insights and contributions, and to all of you for coming. And I think a round of applause.